part, how do you feel in the matter of the King on application of Fitzgerald and of Parole?
Mr. Cohen, good morning. Just before we start, I've got a couple of questions which don't feel you have to answer them now, but it would be grateful. I'd be grateful if you could maybe take them on board and either tell us the answer or tell us what your reaction to them is in due course of your submissions or whatever. The first one is it's a sort of mix of a practical one and the application of the rules. The point was made yesterday by Mr. Rule that given the nature of the inter-parties costs in a case like this, and in this case in particular, that the costs order in favour of Mr. Fitzgerald would mean that on any sort of, dare I say, realistic cost assessment, if it was an order for the whole costs, the statutory charge would not affect the damages, because the inter-parties costs would be, for the sake of, I'm just making up numbers, 40,000 claimed. The assessed inter-parties costs would be, say, 30,000 claimed. That would mean that the legal aid budget's costs of 17,000 odd would be covered, and the 10,000 wouldn't ever be, and that would be the end of the statutory charge. And that was the point that Mr. Rule was making to us, and I'd be grateful if you would let us know what your position is about that. The second question, a different question, is whether you're taking a point about whether the specific decision in this case by that occurred, I call it a decision, even that's actually, I think, contested, but the thing that happened, let me put it that way, in relation to the parole board was or was not a judicial decision. It'd be helpful if you could let us know what your position is on that.
My Lord, on the first point, the summary, as you've put it, is correct. So if there had been an inter-parties costs order, then the statutory charge bites on any sum recovered, its property, its cost, it's whatever's paid over, presupposing that the board paid that which it was ordered to pay, which inevitably it would have done. Then what would happen is the statutory charge bites to the extent of the sums expended. So the first 17 of the 35 paid over is what the charge would bite on. And what happens in terms of the payment mechanics is only a solicitor can give good discharge. So the parole board would pay the solicitor. The solicitor would then send the exact amount of the legally aided amount cost, £70,000 to the Lord Chancellor. The rest would then be retained to the solicitor, save for the damages which would have been paid the damages themselves are insulated from that, so the damages would all have been paid. So
the sum would go three ways.
Yes, so the totality would have been paid: 35 costs, 10 damages. All goes to the solicitor. 17 goes to back to the Lord Chancellor. 10 by way of damages would go to the appellant. The remainder would have been kept by the solicitors. So what that would mean is, because the solicitor has already been paid the 17, the solicitors get 35. And then the 10 goes to Mr. Fitzgerald. On the second point, two of the authorities in the hand up, which I hope is on the desk of my lords, my lady, are going to address that point.
I see.
And there are four authorities there, but I will, if I may, just deal with them in the currency of my suspicions as I come to them.
Thank you very much.
My lords, my ladies, so far as the structure of my submissions this morning is concerned, the first point I'm going to focus on are the specific circumstances of the appellant. I do so because if we go back to the question which is an issue here, that question being, in the specific circumstances of the appellant, did the order infringe his access to court under Article 6.1, which begs the question of what were the appellant's specific circumstances and whether the order did infringe the Article 6 rights. And then we come to the logically subsequent question, which is the legitimate aim proportionality. So this first set of submissions is going to focus on the appellant's specific circumstances. I'm then going to make submissions as to whether the order itself infringes the Article 6 rights. And I've trailed in my written and oral submissions yesterday that I say the order doesn't. It is the charge that does, so to speak. But I'll deal with that in due course. Focusing then on the appellant's specific circumstances, this segment of my submission is going to take us relatively quickly, but I'm not sure if regrettably is the right way to put it, but in some depth through some of the legal aid consequences of the facts that he is of limited means. The first thing we need to have in mind are what we know of the appellant's specific circumstances. We obviously know that the legal aid costs at the point of the order made by Mr. Justice Fordham was £17,693. We know from the witness statement in the second supplemental bundle that his disposable income is less than £315 per calendar month. We also know that he was aware of the statutory charge before he commenced proceedings. In the second supplemental bundle index, on page 9, is the witness statement, and exhibit AY2 of the witness statement. This is the second supplemental bundle index. At exhibit AY2, unfortunately, I don't have pagination online. I'm not sure my lords and my ladies if you do, but AY2 I think is.
It's in my PDF. I think it's at page 17.
Yes, I was going to say 17, 18, 19 feels about right. And if you'd be kind enough to go to page 5 of AY2, which would be 22 of the PDF, you will see, I hope, in the middle of the page, assessment summary. It's the final page of what looks like a printout of a electronic form.
The page has a 5 at the bottom.
Yes, 5 at the bottom, I'm grateful. And you will see on the left-hand side...
page 22 of the PDF. Thank you.
These are a series of declarations that the legally aided party makes.
Right.
And this is the record of the declaration that's made. And on the left-hand side, you'll see the various paragraph numbers. It says the client's representative, and there's declaration paragraph 4. This declaration is, forgive me, this is the solicitor's declaration, and it says, client's representative declaration paragraph 4, the solicitors have explained the LA statutory charge to me.
Yes, I see.
So he knew of the statutory charge, and if you go to the client's representative declaration paragraph 10, he was aware that legal costs may have to pay back in full or part at the end of the case. The means declaration, which is on the succeeding page, covers 2 pages. The second page, this is internal pagination 7, so PDF 24, I believe, has what I understand is the signature of the legally aided party. And if one looks 3 bullet points up from the bottom, it says the legally aided funded party may have to pay back all or part of the legal costs at the end of the case. My lords and ladies, that is more or less everything we know about the appellant's circumstances. And I'm now going to make submissions on the fact of legal aid and how it is that he receives a series of benefits that are denied to a privately paying party, which are going to be relevant when we are identifying at all stages of the Article 6 sequential tests whether the order itself, presupposing a restriction, has had a disproportionate relationship between the end and the aims. In the authorities bundle behind tab 7 is LASPO. This is authorities bundle behind tab 7. Yeah. Section 11 is the qualifying for civil legal aid. 11.1 provides that the director's got to determine whether an individual qualifies, and then section 21, this is 11.1a, provides for regulations. There are in the bundle the civil legal aid, financial resources and payment for services regulations behind tab 11. They are there, but I think just for your own purposes, civil legal aid only kicks in if an applicant has got a gross income of less than £2,657, and if the gross income is less than £2,657, this is monthly income, a disposable income of less than £733 per month. As I say, I can take you to those regulations. They are there in the bundle if needs be, but I think for these purposes, one can take it as read that the qualifying criteria for civil legal aid are relatively stringent. So far as the operation of the scheme is concerned, a legally aided party under no circumstances is liable to pay for the services rendered to the solicitor. So by that I mean liable to the solicitor. Section 23, which is at page 51 behind the tab that you have opened, is the current version of a statutory prohibition on the party making payment for services to the solicitor, which has existed since legal aid was introduced in 1949. So that's section 23(1).
So did you say that was in the bundle? No.
Yes, sorry, it's page 51, section 23(1) of LASPO. Page 51, behind tab 7.
Thank you.
23(1) says cannot be obliged to make payment except where the regulations provide otherwise. And the regulations that provide otherwise are the ones that provide for income contributions throughout the lifetime of the case. You qualify if your disposable monthly income is less than 733, but if it is more than 315, you have to make relatively small contributions. If it's less than 315, then you don't make any contributions whatsoever. So that's the reference to the regulations. But what section 23 does, when allied with section 28 is at 62, and it's section 28(2) at 62, provides that the service provider is not able to take any payment other than that specifically authorised by the Lord Chancellor. Now, these two provisions working together mean that in no circumstances is the legally aided party ever liable for legally aid costs. The solicitor cannot turn to the client for payment. The client's not liable because of section 23, and the solicitor is not able to take payment because of section 28. And the first authority of the small bundle that I've handed up is the case of Merrick and the Law Society. And it was a case that I mentioned in my oral submissions yesterday. And Merrick and the Law Society makes clear, it's paragraph 16 and 17 as context. There's an agreement between the solicitor and the client that the solicitor could take £10,000 of the damages award. That's 16 and 17 on page 4. The Law Society then did an audit, found this out, took disciplinary proceedings, provided a sanction, and the solicitor then JR'd that. But it's a paragraph 54 on page 13 is a stark expression of the effect of sections 23 and 28 LASPO. Those sections are the successor to the relevant sections under the legal aid book, but there's no difference of substance between them, but it's paragraph 54 makes the point good. That in no circumstances can the solicitor look to the client to claimant, and indeed it is a breach of regulations in fact to do so. The next point is that of the statutory charge. That's 25 of LASPO, which is at page 56. Section 25(1) provides that the extent of the charge, this is page 56, goes to the amounts under section 25(2). 2A are the amounts expended by the Lord Chancellor, and section 25(2)B are the amounts paid by the individual, so in other words, the income contributions. The reason why they constitute a charge is because more often than not the income contributions are not paid in the circumstances they should have been, but if they are paid, then those themselves are deemed to satisfy the charge, but the charge is there just to ensure that the Lord Chancellor gets that protected as part and parcel of the scheme. And importantly, under section 25(1)A, the charge is only on property recovered or preserved or costs payable to the individual by another person in connection with such proceedings. So the charge itself only bites where sums are paid, and it bites only to the extent of the legal aid funding itself.
And damages received is within property recovered, is it?
Indeed, indeed. And the statutory charge manual, which I'll make very brief reference to, just makes it clear that property recovered is deliberately understood to be an all-encompassing term, because what one often has, particularly in some matrimonial cases, or whether it's matrimonial is the right word or not, but where partners buy property together and you have a tolata dispute that then follows, the property recovered actually does deal with changing beneficial ownership and the like, and it's for that reason that slightly opaque terminology is used. The statutory charge has been a feature of legal aid from its inception. Legal aid itself is a function of the Legal Aid and Advice Act 1949, and again, as much for historical reference as anything else, behind tab 4 is section 3 of the 1949 Act, and the statutory charge appears in section 3, 4, and 5. And the statutory charge has continued through the various iterations of legal aid legislation, so the Access to Justice Act, Legal Aid Act, and the like. But as I say, in its original formulation, which is very closely tied to its current formulation, it's there at page 20. The statutory charge manual behind tab 14 sets out the operation of the statutory charge, which my learned friend Mr. Rule took the court to yesterday, but that's at page 139, which just gives a brief description. What is important about the statutory charge, if one goes to page 139, is the purpose of the statutory charge is to ensure that as closely as possible a legally aided party is put in the same position as one that is not. That's 139, and we see that at 2.11a. That's 139, 2.11a. And there's reference there to the case of Davies and Eli, which is also in the bundle, but I'm not going to take you to it unless it be particularly helpful. So far as the statutory charge regulations are concerned, they're behind tab 8. It was submitted by my learned friend Mr. Rule yesterday that the charge here has bitten and it cannot be released. And in my respectful submission, that's incorrect, and I'm going to go on to make that point good. The statutory charge regulations appear behind tab 8, and it's at page 70 that I'm going to respectfully direct your attention, if I may, which is Regulation 5.1. Regulation 5.1d provides that the statutory charge will not bite on any sum if an Act of Parliament provides that it cannot be charged. And there is a case that I'm going to come to called Turkey, where it was argued that insofar as the charge has the effect of breaching a convention right transposed into our national law by the Human Rights Act, then section 5.1d provides that the charge will not bite. And again, I'll make that point good by reference to the case I just mentioned. Regulation 9 is on page 72. Regulation 9 enables the Lord Chancellor to waive the statutory charge, but only where at the point of granting legal aid, the director was satisfied that the proceedings had a significant wider public interest. And part of the case argued in Faulkner was by reference to Regulation 9, but it was actually its previous iteration of, that this should be understood as providing a power to waive after the event, because otherwise there would be an infringement of convention rights. I'm going to take these regulations in reverse order and deal with Regulation 9 first by reference to the case of Faulkner, which is behind tab 41. This is in the authorities file on page 819. It was suggested by Mr. Rule yesterday that this case could be distinguished because there was a costs order laid against the legally aided party in the Supreme Court. And in my respectful submission, that is an unsound basis. I say as much because the statutory charge bites whenever the legally aided costs have not been paid out by reference to an inter partes order and damages are recovered. So it matters not for the purposes of the operation of the statutory charge whether there's no order for costs, whether there is an inter partes cost but the other side doesn't pay, or whether in fact costs are ordered against the legally aided party. None of that makes any difference. The statutory charge regulations bite whenever damages are recovered and there is not funds to pay the legally aided costs.
I mean, I suppose the point proves itself in the sense that if it was otherwise, then there wouldn't have been an argument about it.
Indeed. Indeed. And one can see from F and G at 819, starting at the paragraph on the 17th of April 2014, that the context of this case is the statutory charge entirely insulated from the previous costs orders. So if we go from F onward, that's the point at which the discussion starts. And turning to paragraph 4 at the bottom of 820, what took place was, on the 17th of April 2014, Mr. Faulkner's then solicitors wrote to the legal aid agency asking them to waive the statutory charge. We see that from paragraph 4 at the bottom of 820. The legal aid agency refused on the basis that Regulation 47, which is the previous incarnation of Regulation 9, didn't enable them to do so. Paragraph 5, there was then a judicial review challenging that refusal that was heard by Mr. Justice Mostyn. The first section of the judgment deals with the proper construction of Regulation 47, which is now Regulation 9. And it's not of interest for our purposes, save that at paragraph 21 on 826, the court made the point that its construction of Regulation 47 is the same as Regulation 9 as now is, which means that the Lord Chancellor has only got the power to waive, this is paragraph 21, where a request is made and the director makes the decision at the point that the legal aid certificate is granted, so one can't do it after the event. But at paragraph 25, we have a series of paragraphs under the heading Freestanding Human Rights Arguments. Paragraph 26 makes the point that the breach was in Article 5.1, as is here. Paragraph 27, the first sentence makes the same point as is made by the appellant here. Third sentence, paragraph 27, deals with full redress, victim state, which is all a nod towards just satisfaction. Paragraph 28 deals with the submission, which is part and parcel of the appellant's case, that Article 5 or Article 5.4 breaches in Article 5 should be treated differently from any other breach of convention right. Paragraph 29 onwards addresses the case of Scordino in Italy, And then from paragraph 31 is a series of reasons as to why it is the charge does not breach convention rights. Paragraph 31 says that one doesn't treat Article 5 any differently to any other breach of convention right. It's 31. (32) distinguishes the case from Scordino. (34) makes the point that had it not been for the unsuccessful challenge in the Supreme Court, the statutory charge wouldn't have needed to bite because there was a costs award in his favour in the Court of Appeal. So the statutory charge there bit because, albeit where it would not otherwise have done, because they did benefit from a costs inter partes costs order in the Court of Appeal, but they then appealed to the Supreme Court and then saw the position unravel as a consequence of the costs order being made against them, which would have been set off, or either would have been set off and or it would have led to the Court of Appeal costs order being overturned. And the words by H in 34 in my submission bear close reading. Just like any other litigant, he and his then advisors were responsible for the scope of the case which was advanced and ought to have taken into account the possible consequences and should have conducted a cost-benefit analysis. The statutory charge manual itself explains in the extra set of paragraph 9 above, the statutory charge is intended so far as possible to ensure legally aided litigants are in the same position as successful non-legally aided party. And then over the page, it seems to me at all times Mr. Faulkner, like any other litigant, was subject to the risk of litigation, should have taken them into account. And then 35 makes the point that if the argument was to succeed, then a legally aided litigant would be placed at advantage over one who's privately funded and would be treated as if his convention rights were more extensive or entitled to greater protection than that of a privately funded. My Lords, the next case I'm going to take you to is a case that deals with Regulation 5. You'll recall that Regulation 5.1d says that the charge will not bite on any sum if there is an Act of Parliament that has the effect of providing that it should not. And behind tab 39 is the case of Turkey and the Director of Legal Aid casework. Again, this was a case that you were taken to very briefly by Mr. Rule, but it does bear closer examination. This case was an employment tribunal case. Exceptional case funding was granted. The individual applicant was a victim of modern slavery and was awarded, and this is the final sentence of paragraph 4, the total figure of 266 against her previous employers. That's paragraph. Paragraph 5, 4 lines up from the bottom. What then happened is that Freshfields undertook enforcement on a pro bono basis. Paragraph 6, before interim charging order was made, the previous employers sold their only assets. And then in the first 2 sentences of paragraph 7, the effect of that was that only £35,000 was recovered. If I could just invite you to read paragraph 7. So the consequence was that the charge took the entirety of the sum recovered, £35,000. The argument was then put that that would have been a breach of convention rights for the start of the charge to have that effect. And then at paragraph 16 on 765,
So before we go on, the argument would be the same, would it, if an order had been made in the tribunal proceedings that she should recover 13% of their costs, and they then paid it? I mean, it's the amount that's received, not...
Absolutely, it's not the mechanism.
So, I mean, if there had been a costs order, but only to something like that extent, we would arrive at the same position going on from there.
Indeed, or indeed if they'd been a full cost order, but they only had the assets of, or only had the ability to pay £13,000.
So there are many routes by which one might arrive at the sum which is in fact recovered.
Indeed, and because the charge only bites on the facts recovered, it might be that they take their assets out of the jurisdiction, they don't have the money. It doesn't really matter how one gets there because the charge will bite on the sums recovered. And where there is a shortfall between the sums recovered and the legally aided costs, the charge will end up subsuming everything that has been recovered as here and as there. And at paragraph 16, what is said is that if the effect of those facts, in other words, the charge subsuming the damages, whether one calls it damages or debt or amount paid, if the effect of that is to breach convention right, then the charge will not bite because of regulation 5.1d. From paragraph 22, we see the Article 6 argument, which again is the mirror of the one that is run here. Paragraph 27. Last sentence 27 makes the point that Article 6 is concerned with access to justice. It does not act as a guarantee that the aggrieved litigant will recover from the perpetrator of the civil wrong. And then if I can invite you to read paragraphs 31 and 32. And then in the subsequent paragraphs, which I'm not going to take you to, Article 4 is then dealt with another contravention. Article 1, Protocol 1 is dealt with. Article 14 is dealt with. Trafficking Directive, and then the conclusion at 63 on page 780 simply says, in the first sentence, no article in the ECHR and no provision of EU law renders the statutory charges as applied to the claimant unlawful, and no claim for judicial review must fail.
Could you just go back a stage and help me as to the difference between Regulation 8 and Regulation 9 in terms of authority to waive and waiver in significant public interest cases?
Yes, of course. So if one goes to page 71 of the authorities bundle, what you've got in Regulation 8 is authority where the statutory charge is in favour of the provider. Now, there is one circumstance where the statutory charge is in favour of the provider, and that is in family cases. So in family cases, if it's regulation...
Provider being the solicitor.
Exactly. That's the only... So the Lord Chancellor can waive the statutory charge when it's in favour of the solicitor, so it secures sums that the solicitor it would otherwise be entitled to, but that only bites where Article 4.3 bites, and that's a specific provision for the costs of providing family help.
I know we were taken through these yesterday to a degree. So
Regulation 7 provides the statutory charges in favour of the Lord Chancellor, except in the circumstances in paragraph 2. And paragraph 2 says statutory charges in favour of the provider where Regulation 4.3 applies, and no certificate has been issued. Regulation 7.
Regulation 7, thank you.
and then 8 is parasitic on 7. Now, the reason why Regulation 4.3 provides for this slightly unusual mechanism is because where family help lower is provided, no certificate is granted. In other words, what takes place in reality is normally the service provider goes and has got delegated authority and issues a certificate where there's delegated authority that's granted. But where you've got family help lower that's provided, which is Regulation 4.3, it is in a sense a sum for this specific echelon of service provider for family help right at the beginning of some family proceedings for which no certificate needs to be
So
provided.
could you just talk us through the situation that would arise in a family case where consideration was being given to the operation of Regulation 8? Where does the money end up? Let's suppose money is recovered from a family house, and there is a certain amount recovered. You would need it all to rehouse children or something of that sort. And what happens if that charge is or isn't waived?
My lord, you're going to have to forgive me because I can speculate as to what I think the answer is, but I'm not going to pretend I've got this.
Your speculation will be in advance of knowledge on my part anyhow. So
The short answer is that in the facts that you posited, it wouldn't be family help lower. The certificate would have been granted because it would have gone to legal action. So family help lower tends to be, as I understand it, things like early stage mediation.
yes, well, let's stay with this. This has gone through a whole process. It was a full legal aid certificate, and some money has been recovered. So what difference does it make, A, to the client and B, to the solicitor, if the discretion under Article 8 was to be exercised
Well,
by the Lord Chancellor?
on those facts, there would be no discretion because the certificate's been granted. So Regulation 7.2b, as soon as you get a certificate, one goes out of this very limited exception whereby the statutory charge is in favour of the service provider. So if one were to posit the situation where there'd been no certificate, we're in an early stage mediation, there'd been some kind of settlement, then the charge bites in favour of the service provider. It can be waived by the Lord Chancellor, but I'm afraid that's as far as I can go without, I'm afraid, going from the realms of speculation.
So the assumption you're making would be that the cost would then be borne by the Lord Chancellor. It isn't that money would be taken off the solicitor to pay the client.
No.
It's simply the Lord Chancellor would bear the cost of the early help.
Exactly. But as I say, that the Regulation 7.8 is for a very, very limited exception.
Right, so that's the takeaway, is it, from this, that there is no general floating power to waive the charge, even in cases of grave distress, a grave hardship or distress, or unreasonable difficulty.
No, the only power, as I say, I'm putting that very limited exception to one side because it's pre-issue for a certain type of family proceedings.
Thank you.
The only power is Regulation 9, and that has to be in circumstances where an applicant goes to the director and says, please can I have a certificate? By the way, in advance, I'm going to invite you to operate your discretion under Regulation 9. After the event, there is no discretion. The pressure release valve is that which one sees in Turkey, which is that the statutory charge will not bite if the effect of so doing is to breach a convention right. But there is also another suite of benefits that a legally aided party gets as part and parcel of legal aid. One is Section 26, cost protection, which is behind tab 7, which you see at 59. Section 26 of LASPO provides that costs ordered against an individual in receipt of civil proceedings and other subject to legal aid must not exceed the amount which is reasonable for the individual to pay, having regard to all the circumstances, including the financial resources of the parties they conduct in connection with the dispute. Section 26.4 then removes certain things from the financial resources of an individual. And then Section 26.5 provides for regulations. So Section 26.1 is why it is that when costs are ordered against a legally aided party, the amount they are to pay is that which is reasonable in light of the financial resources of all the parties to the proceedings, and including them. The regulations which are anticipated in section 26(5) are the civil legal aid cost regulations, which are behind tab 9. The civil legal aid cost regulations deal with two things. The first is how one quantifies the output of a section 26 costs order. So how does one identify what is reasonable for the legally aided party to pay in light of the financial resources of all the parties, and also provides for costs against the Lord Chancellor. Costs against the Lord Chancellor is available in very limited circumstances where a section 26 costs order is made. And again, I'm going to touch on this very briefly, because one of the points that I make is that with one eye on equality of arms type argument, if costs had been ordered against the appellant would have had to pay nothing because of his resources, and the board would not have been able to recover anything from the Lord Chancellor. Regulation 9 on page 86 provides that only if the conditions in this part are engaged, can the Lord Chancellor pay the whole of a costs award made against a legally aided party. Regulation 10 provides for cost orders against the Lord Chancellor. And Regulation 10.3 then sets out the preconditions. So first you've got to have, this is 10.3a, you've got to have a section 26 costs order. In other words, they've got to be costs ordered against the legally aided party. And then 3c provides that costs in a court of first instance will only be ordered against the Lord Chancellor where the proceedings are instituted by the legally aided party. The non-legally aided party is an individual, so that obviously takes the board out of consideration. And the court is satisfied that the non-legally aided party will suffer financial hardship unless the order is made. And D, in any case, the court is satisfied that it's just and equitable in the circumstances for the provision of costs to be made out of public funds. So in appellate proceedings, one can get costs out of the Lord Chancellor. But in any event, there is still a just and equitable test. But at first instance, the legally aided party has got to be the claimant, the non-legally aided party has got to be an individual, and the non-legally aided party has got to suffer financial hardship unless an offer is made. Regulation 13 then dovetails towards the assessment of resources where a Section 26 order is made. Section 26 order is made will provide that the amount the legally aided party is to pay is that which is reasonable, and then you've got a series of regulations starting from Regulation 13, which provides for a mechanism for how to determine how much the legally aided party is to pay. And of note is the fact that the first £100,000 of the value of the legally aided party's interest in the main or only dwelling is excluded. That's 13.1. I make one other point with reference to Elisabeth at this stage before I'm going to take a step back and I juxtapose the position of the two parties. You may have seen references in Parole and the Court of Appeal in the Supreme Court to the fact that for the purposes of a costs order, the fact that one party is legally aided is irrelevant. That deals with the incidence of costs, and that's a function of Section 30 of LASPO, which is at page 64. However, for the purposes of an Article 6 examination, because you look at the legally aided, well, you look at the applicant's specific circumstances, it is through that lens that the fact of legal aid is relevant. But I simply make that point in passing in case it was troubling the Lordship's relation. So far as a party in the position of the appellant is concerned, they receive the following benefits compared to a non-legally aided party. The first benefit they get is they pay nothing up front. Nothing up front. The next is that a legally aided party will never be worse off for litigating. They cannot be, because the charge only bites on sums recovered. They might be in a neutral position, they'll never be worse off. The next benefit they get is that the amount of the charge is referable to the amounts expended by the Lord Chancellor. So in fact, in circumstances where their charge bites, it bites to a level which is far below market rates. I'm going to take you simply to one schedule in the Criminal Legal Aid Remuneration Regulations 2013. These regulations set out the amounts that are paid by way of legal aid. And on page 111 of the authorities bundle, is table 10. And one sees that 111 at table 10A and table 10B, this is the amount that solicitors get paid. For preparation and attendance, it's £70 for a London rate. Now that's obviously measurably below what the market would provide. And the final one is a party in receipt of legal aid has section 26 protection on any costs they have to pay. The position, however, of a party litigating against someone who's legally aided, whether it be the board or anyone else, is measurably worse. So if you are litigating against a legally aided party and a cost order is made against you, you have to pay costs at inter partes rates. That's page 95 of the bundle, which is Regulation 21 of the Civil Legal Aid Cost Regulations. And at page 95, Regulation 21 is the regulation that provides that where a costs order is made in favour of a legally aided party, sums are to be paid at inter partes rates. What Regulation 21(3) does is make it clear that the indemnity principle, which would otherwise limit the amount that the paying party had to pay by reference to the expenditure on legal fees on behalf of the legally aided party, does not apply. Statute disapplication. So what it means is that if you're litigating against a legally aided party, you have got to pay full inter partes rates if a cost order is made against you. However, if a cost order is made in your favour, you are highly unlikely to get anything from the legally aided party because of section 26 LASPO. And as we have seen, the conditions for getting costs against the Lord Chancellor are very heavily circumscribed.
If familiar with getting to the point of considering whether to make orders and assess amounts against legally aided individuals. But if one gets into this process any further, the Lord Chancellor becomes involved as is given notice of those.
If costs are being sought against the Lord Chancellor.
So yes. As it were, the successful party facing a legally aided applicant will then be faced with having to overcome any objections made by the Lord Chancellor relying on the regulations.
Yes, so what happens is a bill is put in to the SCCO and a cost judge notifies the Lord Chancellor. The Lord Chancellor puts in submissions if the Lord Chancellor wants to. By and large, it tends to be happy to leave it to the good judgment of the cost judge, and then you have a full cost assessment, but the Lord Chancellor is on notice. And there's some quite strict timelines in Regulation 10 about when you've got to start. It's got to be within 3 months and the like, and occasionally the Lord Chancellor takes those points, but it is properly assessed by the SCCO in due course with notice to the Chancellor. Now, all of that begs the question of the next step in our fourfold test, which is, given those specific circumstances of the appellant, has the order infringed his right of access to a court under Article 6? And in my respectful submission, the answer to that is no. And the reason for that, this is the order for costs, is because the appellant has got no liability to pay his own fees, full stop, section 2328 of LASPO. So the order, and it has to be the order which infringes the Article 6 rights, does not do so, because in no circumstances can the legally aided party be liable for costs at all. If anything, it would be the statutory charge. But that is a matter between the Director of Legal Aid Casework, in other words, the legal aid agency, and the appellant. What should happen is the appellant should go to the legal aid agency and say, if you enforce this charge against my £10,000, you will be breaching my convention rights. The legal aid agency will then consider Regulation 5.1d and take a view. And that's why in all of the cases in the bundle, the material cases, what one sees are the convention rights arguments being deployed against the statutory charge. So it is not this order that infringes any Article 6 rights. If anything, it is the statutory charge. In any event, when considering whether there is an infringement of Article 6 rights, one can only do so with reference to the specific circumstances of the appellant. And it's those specific circumstances that I've devoted the last 45 minutes of my submissions to, and those specific circumstances place someone in receipt of a legal aid at a measurably better position than that of a private paying party. And I opened my oral submissions yesterday by making an impressionistic point that if the appellant had been a privately paying party and there had been a costs order in favour of that privately paying party against the board, that privately paying party would be in a worse position than the appellant finds himself in. It would have cost you £15,000, £50,000, £60,000 to get there. The board would never have had to pay anything like, say, £40,000, given the proportionality test. This was a one-day hearing, £10,000 and the like. And then the shortfall would have eaten up anything recovered, and it would go beyond that, and there would have been a debt due from the private paying party. My lords, my lady, that deals with the first two sequential questions, the appellant's circumstances and has the order infringed his Article 6 rights.
It's one question to ask whether the order infringed his rights. Is it another question and a different question, or the same question, to ask whether the order made a big difference, to whether he was going to get his damages?
In my submission, it is a different question. There's no doubt that if a costs order had been made, he would have recovered his damages, but it is not the order that makes him liable for his costs. If an order was made and not satisfied, for whatever reason, the appellant would be in exactly the same position.
But if we're looking at the specific circumstances, as you keep telling us, you were obviously going to pay the damages, pay the costs if you were ordered to pay it.
Of course.
And the argument being made against you under, we didn't hear much about it, but we're aware of it, under Ground 7, is that either Davies didn't apply or the judge was wrong to apply it. He should have made a costs order because he won. And that if that is the case, and he received even a substantial costs order, if not a total costs order, his damages would have been spared. And I don't think in fact you helpfully as it were, corrected us earlier on, so that we have in full view the fact that that is the actual situation here. And so, is there a risk that somebody in this position is always met with an argument saying, you know, nothing to look at here, it's always somebody else's responsibility, but that when we look at the real concrete situation, as Europe is so fond of describing it, actually, if the judge made an error, that is an error that bites on the Article 6 right.
My Lord, in my respectful submission, that point would have a great deal of validity if we were dealing with a privately paying party. Because the privately paying party has got a contractual liability for their costs. And if this were a privately paying party, one could see how the order infringes Article 6 rights. But what we've got here is an opportunity, well, not opportunity, the appellant has got the right to challenge the statutory charge, and it's the charge that renders his damages a thing writ in water rather than costs.
The way you would distinguish it, if I'm understanding correctly, is that if the privately paying party was disabled from getting their the costs that they had spent back, then that would be one thing. But defending an award of damages from the effect of an order or no order for costs is another thing.
Indeed. And as I say, it would be a very interesting appeal if this were a privately paying party with a contractual liability for costs, because they can say this order infringes my Article 6 rights. But where you have got, which is why what took place in Faulkner took place, which is the challenge to the statutory charge, the actual infringement of the rights, which is the point at which the damages are evaporated. In other words, there is non-receipt of damages. The non-receipt of damages is because of the charge. It is not because of the order. And that's why in the cases that, first, one presupposes that's why Regulation 5.1d says what it says, which is the statutory charge will not bite if it infringes a convention right. And that's why the case of Turkey deals with it through that lens, and equally the case of Faulkner does the same thing. Because what one is interested in is, why has the appellant not recovered the damages? And the answer to that question is not because of the costs order. The costs order would have enabled him to do so, but the reason why he hasn't is the statutory charge.
I'm not sure I'm following this at all. Isn't one of the issues raised by this appeal whether the judge below was bound by the two cases that he relied on to hold that a costs order against the Parole Board was not something that he could make? And one of the arguments is, well, the cases about costs orders against the Parole Board are different in two respects, because in those cases the Parole Board didn't take an active part in the case, and also the Parole Board had simply made a decision, one decision, which the court quashed, whereas it might be thought this is a very different case because the Parole Board had breached the appellant's Article 5 rights and been ordered to compensate him for that breach with an award of Human Rights Act damages. So at some point I'd be helped by having it explained to me why the judge was bound by the cases that he relied on to reach the result that he reached.
My lady, I'm going to come on to that in the context of legitimate aim, because that's the next set of my submissions.
Yes,
in other words,
the premise of your argument so far is that the judge was perfectly entitled to make the cost order, which he did, and that's one issue. But there's a more fundamental issue, it seems to me, which is, was he?
Well, the way that I put my arguments is to take the fourfold sequential steps that have been put forward through the various cases that I took this court through yesterday afternoon. Again, the first is to identify the applicant's circumstances, the next to identify whether the order infringes the Article 6 rights. If we presuppose the answer to that is yes, we then come to the legitimate aim point, which is the point at which we come to Davies. What was the purpose of Davies?
Just as we go into legitimate aim, I'm understanding correctly, your argument on interference is that it doesn't matter what the costs order is. I mean, whether he got a full costs order, no costs order, or something in between makes no difference, because in sense you're pointing that argument to a different parties, different regime, and so forth.
Exactly. So when we come to the second question, which is, did the order infringe the Article 6 rights? The third is, if it did it have a legitimate aim? The fourth is the proportionality question. On the second question, I say the order didn't, the statutory charge did, and in which case the appellant should be saying to the director of the legal aid agency, don't enforce the charge because it would infringe on my convention rights. That's what the board's position on question 2 is. Question 3 presupposes that question 2 is answered against the position that I've just set out, and that's when we talk about legitimate aim. In other words, what is the purpose of Davies? The purpose of Davies is set out in paragraph 22 at Davies, which is at 279 of the authorities bundle. This is tab 23, 279. The purpose of Davies is in paragraph 22, 279 of the authorities bundle. I misdescribe it as the purpose, but that's why I'm going to come on to what the purpose of Davies is, if I may. But the point in paragraph 22 is that tribunals exercise a highly specialist jurisdiction, and it often happens that such tribunal might wish to represent it before the court to explain matters relating to its jurisdictional procedure or to draw the court's attention to relevant decisions overlooked by the parties without in any way involving itself in the list or contesting the application that was made. The purpose of the rule is in paragraphs 49 and 50, which is that if a costs order was to be made against a party who is simply there to assist, they would not appear, in which case the court would be deprived of that specialist knowledge and information and would have to seek an amicus. That's 49, 50, and 58.
So is your submission that the parole board in this case simply appeared to help? Is that your submission?
I'm focusing on the rule in Davies at this stage, but I'm going to go on to what the parole board said to the court below. But again, because we're asking whether there's a legitimate aim, on this basis we're presupposing that the order has infringed, and what the judge did was reflect the practice in Davies in the order. The aim of the rule in Davies, the practice in Davies, is to ensure that a court has the specialist knowledge and information of the tribunal, or whatever guise it might be, available to it. And the reason why costs are not ordered where that tribunal takes a neutral stance, in other words, puts the information to the court, is because if it were made against it, they wouldn't attend, which would then leave the court to have to try and find an amicus, which has been described in this case as a much less desirable alternative. We have that in 49, 50, and 58. I took you through yesterday afternoon the various cases which are dealing with legitimate aim of different provisions, and I made the point that the hurdle was low. But so far as Davies is concerned, this decision, which sets out a series of conclusions from miscellaneous decisions, makes the point that that specialist knowledge that the tribunal has is beneficial to the court, and the reason why you don't order costs is for fear that that inferior tribunal would then not give that knowledge, and the court would have to appoint an amicus. That's 49-50, and then it's made again at 58. And again, Goulet in the Court of Appeal.
I'm just trying to understand why it's so important in the minds of that court as to whether the inferior tribunal showed up. I mean, I can see that there might be cases of great esoteric tribunals, but the Parole is not an esoteric tribunal. In a sense, apart from opening its files and saying this is what happened in this case, it brought nothing to the table. And the High Court was perfectly able to determine the case without specialist assistance. I thought that the issue of costs depended upon not whether they showed up when they were JR'd, but what they'd done or not done when they were exercising their responsibilities.
Indeed, but and we see that from paragraph 47. And what 47 provides is what to do depending on the behaviour of the inferior tribunal. But the practice in Davies is that if you are neutral, you are not the recipient of a costs order. That practice has got to serve a legitimate aim, and it's paragraph 22 and 49 and 50 that set out what the legitimate aim is. But 47 is, as you've correctly pointed out, my lord, that the output of the fairly exhaustive series of cases which has gone through in this decision, the output of that means that if the board was not neutral, then under 47.3 it would be liable to face costs. And that's what grounds 7 and 8 is. Of course, what the judge concluded was that the board was neutral.
I can appreciate that I'm not talking about your board, but that a tribunal might run up the costs by adopting a contentious position and that the whole thing might expand. But are we not at root when considering the question of costs? Is the court not at root looking at whether, in effect, in relation to the underlying issue, the applicant for costs has won or not? And that's really what is at stake here. And isn't this question about whether the tribunal has contended a rather subsidiary matter?
Well, I mean, the real issue is whether the board entered into the fray. But what Gourlay and the Court of Appeal says is the general rule of the winner pays the loser's costs is not apt where you've got someone who is entirely neutral. So that's the reason why that general cost rule yields. And that's because where you've got a neutral party, CPR 44, was not designed to come.
I suppose in a completely different context, A sues B. A has got excellent rights to enforce against B. A wins. I mean, of course, the amount of costs might be affected by whether B showed up, whether B put a good case, fought points and so forth in the normal way. But I mean, those are all matters that are relevant, aren't they, to the extent of the costs? What have they got to do with the merits of a costs order in the first place? I appreciate a lot is said in this court and in the Supreme Court about this matter, but at the moment, I may have lost the thread from yesterday about why Gourlay says this is all right. But isn't this focusing narrowly on the conduct of the litigation rather than looking broadly at why there was litigation in the first place?
Perhaps I could take you to Gourlay in the Court of Appeal just to put a little.
I'm sorry, at some length to just make you aware of the fact that I've lost the thread of that argument, and we'll need to pick it up again.
I'm grateful for that. Perhaps if we go to Gourlay in the Court of Appeal, which is page 713. And if I can just take you to paragraph 58.
58.
58,728. And also paragraph 29, which contains a discussion about CPR 44. Yes, that's exactly what I wanted, yeah. 25, 26 and 29. There is a degree of further colour put on what it is that an inferior court or tribunal should be doing when it takes that neutral stance. In the case of Special Tribunal and the State Police Association, which is a decision of the board behind tab 53.
Just before we leave paragraph 58 of Goulet, what Justice Higginbotham says it describes the principle as, unless it's acted improperly, it was actually participated in the challenge, blah, 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 not required to pay the costs of rectifying one of its orders. I mean, is this a case that's about the board rectifying one of its orders, or is it about the board compensating somebody for 10 months of deprivation of liberty?
Well, I think in that context, the order would be the failure to list, which I'm going to come on to, so to speak. But
right. I mean, this Goulet itself was simply an application of judicial review of a specific decision which the court quashed. And would you accept that that's rather different from this case?
I think the principle from Davies, and it's a principle that, so I'm going to, if you just bear with me for a moment, just a bit of flesh on, is not to be distinguished irrespective of the relief that's being sought, because the principle bites on the behaviour of the inferior court rather than the remedy that's being sought against it, if I can put it in those terms.
But the remedy is in respect of effectively an unlawful deprivation of liberty lasting 10 months. Isn't that rather different from simply an unlawful decision?
My lady, respectfully, I say no, because the focus is on the role that the inferior tribunal court is playing in the subsequent proceedings. Is it neutral and providing its specialist knowledge, or is it actively defending the decision that has previously been taken? and certainly the board's position in my submission is that it's not the relief that's relevant, it's the behaviour of the inferior
So
tribunal.
it's simply a narrow focus on the behaviour in the litigation rather than on anything that provoked the litigation. Is that it?
Absolutely. The whole purpose of the rule of practice in Davies is to ensure that an inferior tribunal that turns up and doesn't defend its decision but puts its specialist expertise at the door of the court that's then adjudicating on the relief is not dissuaded from turning up by fear of a cost order being made against it. But what I will say, if one goes to Davies, is that paragraph 47, as I made mention of yesterday evening, has got those two pressure release valves. So if one goes back to 47 on 286, (47.1) provides that a costs order will be made where a tribunal unreasonably declines or neglects to sign a consent order disposing of the proceedings. And then, of course, 47.4 makes the point that the court might exercise their discretion in a different capacity where a successful applicant has financed his own litigation without external funding can be compensated out of a source of public funds and not put to irrecoverable expense. So 47.1 and 47.4 is what I described as the pressure release valves to ensure that, injustice is a slightly nebulous way of putting it, but to ensure that the court that is providing the relief can do so fulsomely whilst respecting the principle in Davies, which is to ensure that the specialist knowledge is there for the tribunal rather than the court having to get an amicus to explain exactly what it is that goes on.
To test the situation, let's contrast a situation where here somebody is not released because the parole board doesn't hold a timely hearing, and an alternative, maybe rather improbable factual situation where an individual's release was directed by the parole board, but the direction got held up in the governor's office and sat on for 10 months, whereupon the individual is released and sues. No difficulty there.
Secretary of State of Justice is going to be
responsible for that. Yes. So coming back then to the justification for the difference.
Because the Secretary of State of Justice is not turning up in a quasi-judicial capacity with the intention of ensuring that its specialist knowledge is there for the court. What it's doing
it's a pure protection for those who act in a judicial or quasi-judicial capacity.
It is exactly that, and it is to ensure that they are not dissuaded from turning up and giving their specialist knowledge to the court.
It's your further point that is causing me perplexity. If you've done something wrong, the consequences are not primarily to be measured by what you then decide to do next.
My Lord, as a kind of broad proposition, I don't dissent from that, but that's why the rule and practice in Davies in paragraph 47.1 and 47.4 has got these two pressure release.
Well, the first pressure valve, as you describe it, is not just unreasonably neglecting to sign a consent order. It's described as a flagrant instance of improper behaviour, which is another example in which the practice wouldn't run. I'm sure that expression finds roots in the previous authorities. But how are we to distinguish, to put it very crudely, not attending to somebody's liberty for 10 months from flagrantly improper behaviour?
Because flagrant and improper behaviour is not the only qualifying criteria, so to speak. The other one is where they have unreasonably declined to sign a consent order,
We
which
could,
might not
paragraph
be
47(1) would read as would be meaningful if you stopped after behaviour. And there's then another instance. Or.
Indeed.
So what is it in Davis that is disabling a court from making a costs order against a tribunal that simply doesn't do its job?
Well, it's 47(3), which is the disabling.
One immunises a tribunal that simply doesn't do its job because one doesn't want to discourage it from coming along and helping you.
Well, the answer is unless one of the pressure release valves in 47(1) or 47(4) are present, then yes. But what it means in practice is that if you've got a decision-making body that makes a decision which is wrong and then takes a neutral stance, your way to ensure that you get a costs order is either through the gateway in 47(4), which is that I'm a private litigant and I'm going to be put to irrecoverable expense, or it's going to be to send them a consent order and then say, well, they unreasonably refused to sign it.
Can I ask a slightly different question? When Lord Justice Brooke was delivering this judgment, could he have anticipated that there might be a case in the future where the parole board would be seeking to take advantage of this rule in circumstances where it had pitched up and fought the case and was responsible for 10 months of unlawful detention? Could he possibly have had that sort of case in mind when he made this broad statement?
I mean, in my respectful submission, I'm going to be told behind me if one of these cases deals with that point square on, but it's paragraph 47(4), which is the release valve. In other words, if you've had to use your own money to get there, to get the remedy, then the court might take a different approach. A number of important considerations might tend to make the courts exercise their discretion in a different way today in cases under Category 3. Sorry, my lady, I do say respectfully, we obviously don't accept the factual premise, which is that the board pitched up and actively fought. I'm going to come into some of the documentation for a moment, but I understand the thrust of the question. But that, in my respectful submission, is answered by 47(4), which basically provides that in circumstances where you've expended money and there might be some form of injustice, the general rule will bend.
Can you remind us when the parole board was accepted? What was the decision that accepted the parole board as a tribunal? I think we were told yesterday, which were amongst many authorities.
The answer is a case called Brooke, but my learned junior is.
Again?
It's a case called Brooke, but my learned junior is going to go back to.
Well, do we have an approximate year for Brooke?
I think it was 2005, but it's not in the authorities.
She thinks it's 2005, but she will check now. So
Well,
to
I mean,
speak.
it's only obviously of some relevance because we need to, as it were, put ourselves in the seats of the court in Davies to understand what it understood it was talking about.
But of course we know obviously from Corley that Davies applies to the board. It's not as if that Davies applies to the board, because that was the discussion in Corley, the principal point, which was whether in fact the board itself falls within these criteria of the inferior tribunal for which this practice is developed in paragraph 47.
Is there a slight danger that we're parsing these decisions as though they were statutory provisions rather than decisions of the court on the facts that were in front of the court when the court made the decision?
I think yes, but the reality of this is that the discretion of the judge remains. This is simply a rule of practice. It doesn't.
Well, it's a very, I mean, the effect of Davies is it's extremely circumscribed discretion if Davies says what you say it says.
Well, I think I wouldn't go as far to say that it's extremely circumscribed, because what we have in 47(4) and because I know I've been beating that drum, possibly a little bit too often, but you do have in 47.4 this ability to take a different stance.
Well, that's for privately paying people.
Yes, but it's difficult in my submission in the context of costs to see in what other capacity where you've got the only other type of individual, so to speak, are going to be the legally aided ones who've got the ability to challenge the statutory charge pursuant to Regulation 5.1d. It's not immediately clear to me in the context of costs as to any other type of litigant, so to speak, that one would be concerned about. You've got people who are privately paid and therefore have to arguably be put in a position of injustice because they've had to incur costs in respect of a decision which should not have been made, or you've got someone who is legally aided who then has the statutory charge to then deal with, but the statutory charge regulations enable that statutory charge to be exempt on exactly the same basis. It's being put forward by the appellant. And it's in the context of cost, one is only really going to be dealing with two types of person. One is falls in 47.4 and the other is legally aided one who've got their own bespoke mechanism for ensuring the charge doesn't eat too far into the damages, or indeed doesn't eat at all into the damages. My Lord, my Lady, I was going to, if it suits the court, just move on to the Privy Council case of Special Tribunal and State Police action, which adds a little bit more as to the Brooke decision was 2008. The Special Tribunal decision, which is the last word, so to speak, in 2004 on what it is that inferior tribunals who are attending before court should or should not be doing, should not being what took place in this particular decision. Behind tab 53 at page 1152, the tribunal there was a special tribunal, which was a body responsible for determining disputes between estate constables and employers. That special tribunal, paragraphs 12, third line, special tribunal opposed the application, so this was a JR of its decision, and appeared by senior and junior counsel. It raised two grounds of opposition, both the jurisdictional one and then what then took place is the special tribunal itself was dissatisfied with the judgment of the High Court that it was amenable to judicial review. It took the view that it was not amenable to judicial review, so it appealed. And then at 17, it then appealed the Court of Appeal decision as of right in respect to both of the issues it lost before the Court of Appeal, which one sees at 17. The first was whether decisions of the tribunal were amenable to judicial review, and if so, whether its decision that it lacked jurisdiction was wrong in law and should be set aside. The board set out its decision, which goes up to paragraph 38, but then at paragraph 39 makes some remarks about the role of the tribunal in the proceedings. Third sentence of 39, the tribunal participated in the proceedings in the manner to be expected from an ordinary litigant engaged in adversarial dispute with another party. And then position in principle is set out at paragraphs 56 and 58. Davies is referred to at 51. We see Davies at 51, and then at 56 and 58 makes the point and particularly 58. There are cases in which a more active participation than is usual may be justified to ensure the course informed of relevant law and potential arguments, particularly if the case raises a difficult or important point of law which otherwise go by default. Providing any assistance, however, the tribunal as advocate should view their role as similar to that of an amicus or an advocate to the court. It's essential that they maintain a strictly neutral stance and avoid adopting an adversarial role in litigation. I'm just going to take the court to, if I may, a number of documents that set out the position taken by the board in this matter. I'm obviously conscious of the fact that my learner junior is going to be dealing with ground 7 and 8 in due course, so I'm going to do so relatively quickly. But at the supplemental bundle at tab 47, you see the skeleton argument that was put before the court. This is page 100 of the supplemental bundle.
Sorry, what did the board decide about the costs, or
The special tribunals, actually, I'm certainly implicit within the special tribunal paper, but just bear with me.
yeah, no, I was just trying to understand paragraphs 59 and following about the tribunal's conduct of the proceedings. I'm not in a position to comment on whether it was appropriately neutral in the proceedings below. And criticised for appearing in the proceedings below. Tribunal clearly lost sight of the principles of impartiality and neutrality. Its decision to bring this further appeal.
I don't recall.
It might be implicit in that, but
It's,
pay the costs in the Privy Council.
yes, I mean, the reality is I assume that's the case, but there's nothing in the decision which says so directly. I'm also not entirely familiar with the cost-making powers of the board in those circumstances. But I mean, the criticism would warrant an audit for costs. I think one can take that as being right. My lady, I'm just going to move, if I may, to the supplemental bundle, and one sees at page 100 the first defendant skeleton argument. This is the board's skeleton argument in the main hearing. Page 100, paragraph 1 makes the point that the board is neutral. Paragraph 3 is the first defendant's agreement with the claimant's case that Article 5.4 applies, and that 5.4 provides that the review must be completed within a time that's reasonable. Paragraph 4 just reflects the neutrality. Makes the point at 4b that delay will be unlawful where there's not been active management of the case. Again, these are the authorities that were there to put and assist the court with making its decision. And then paragraph 5 is the kind of factual clarification which obviously would have come as benefit to the court. 5a makes the point that skeleton refers to a policy which is issued by the second defendant. B makes the point that the first defendant can only review cases which are actually referred to it. C is that the first defendant is independent from the second defendant. And D makes the point that it is functus at the point at which it's heard a review and makes the decision. C makes the point that where damages are the only remaining issue, the appropriate remedy may be the county court. And makes the point that in Roche v. Parole Board, that's exactly what took place. It was dealt with by the county court. 8 makes the point that it is liable for costs if it is behaved unreasonably in failing to bring proceedings to an end. And then 9 makes the point that if it is inclined to do that, then it should be dealt with by written submission. And it's because of documents like these that the judge concluded in his judgment at paragraph 13 that the board was neutral. The summary grounds at tab 16 of this supplemental bundle also reflects that position. Sorry, tab 16 of the main bundle, core bundle. Tab 16 of the core bundle at page 144 is the Parole Board's summary grounds, which is the only other written documentation, so to speak, that was before the court, other than the skeleton argument. Paragraph 1 of those summary grounds, this is 144 of the core bundle, behind tab 16, makes the point that it's there to provide relevant information. Paragraph 1. Paragraph 6 on 145 makes the point that the claimant throughout his time has been described as compliant and respectful, no issues of conduct or compliance. Paragraph 7 makes specific points about the claimant. He's receptive to his work, no issues have been raised. He's used his time to strengthen family ties and good family support. 9 is the reason for the delay. The date of the summary grounds, there is a substantial queue of cases before the parole board. 10 candidly says the parole board does not lack the financial resources to carry out its function. 12 makes the point that the reason for the delay is that there's a shortage of parole board chairs having capacity to conduct hearings, and then sets out the mitigation that's being put forward to make sure that that's not a continuing problem. 15 makes the point that listing is a judicial function, which I'm going to come on to in a moment. Important law is set out at 1670. There were 5 grounds for which permission was sought. Grounds 2 and 3 were a systemic challenge to the policies of the first and second defendants. And so the law in respect to those challenges is set out at paragraph 16 and 17. Ground 1 in paragraph 22 at 153. The board cannot add any further information. It's not resisting, it's accepting it. Grounds 2 and 3, permission wasn't granted on this and was eventually abandoned by the appellant, but they were systemic challenges. And all it says in paragraph 23 is the parole board respectfully submits in deciding whether to grant permission to seek judicial review on grounds 2 and 3. The board should have regard to the summary of principles regarding systemic challenges given by Higginbotham, LJ and Walcott. 24 is the question, but no positive submissions as to what the answer should be is set out. And again, in paragraph 30, grounds 4 and 5 are challenged the board members' decisions to refuse to grant expedition. That decision is a judicial decision. The board does not make any submissions on the question of its lawfulness. This document is studiously neutral, but also, as with the skeleton argument, provides important references to the law, makes points about the claimant's conduct, all of which are entirely relevant to the lawfulness of its decision, makes the point that the appellant at all stages has been very well behaved, gives the reason for the delay, which is not a matter of finance, but a matter of expertise. And all of that is information which is then relevant to the decision, and much of it finds its way into the final decision, studiously neutral, and it provides important important material that the judgment then feeds off. And that is exactly what one would want from a neutral party. It is not defending its decision. It is simply making the points that then find their way into the judgment as being relevant to the decision that is then made. My lords, my lady, for the final 10 minutes of my submissions, I'm just going to deal with the question of proportionality, and I have a number of reasons why in my respectful submission, even if the order infringes the appellant's Article 6 rights, presupposing the legitimate aim of Davies, as I have submitted to this court, is a legitimate aim. And again, with reference to the cases that I took the court to yesterday afternoon, illustrating the legitimate aim is a low bar, so to speak. The proportionality then needs to be addressed, which deals with the nexus between the means employed and the aim sought to be achieved. And I have 6 points. I also have 6 points, and I find I have at least 8. The first point is that the rule in Davies is not prescriptive. There is a residual discretion. That's point 1. That residual discretion is 47.4. Point 2 is that if the appellant wanted it at his costs, he should have made an offer and beaten it. It's clear in 47.1 that an unreasonable refusal to sign a consent order can be a basis for costs. And in Faulkner, the Court of Appeal expressly stated that the appellant should have taken a cost-benefit analysis, and that is what the appellant here should have done. But instead, all of the consent orders referenced a period of delay which was too long and also was nonsensical, as I'm going to go on to show, and saw damages that were 50% higher than was being awarded.
Well, that's a reflection of the period.
It is.
Yeah.
It is. But the reason why that's reflection is because the board quite properly in the tribunal said, well, yes, it was £650 per month in Faulkner, but if we uprate that for inflation, it comes out at about £1,000 a month.
Yeah.
But
I mean,
yeah.
The fact that the compensation of the sort was too high was simply a reflection of the fact that the period of contention that was sought to establish was too long.
Entirely right, Melanie. The only point I do make is that the board quite rightly didn't contest the quantum, in other words, the yield per month.
No.
But yes, you're right. Because the board didn't contest the yield per month, so to speak, then that was the outcome. Behind tab 49 is the case of Summers and the Parole Board. This was a case in which costs were ordered against the Parole Board because it unreasonably refused to enter into a consent order. That's behind tab 49, that's page 1012. At 1012, and it's a short decision which I'm going to summarise rather than taking you through, but it is the best part of the 5 pages. But at 1012, what took place is a prisoner wanted to have an oral hearing and judicially reviewed the board's decision not to hold one, and the board took the position that it wanted guidance as to whether it should. And the judge held that that guidance was set out in the Supreme Court case of Osborne, in which case it should have entered into a consent order disposing of the proceedings. So if one goes to the decision again very quickly, since I'm just time, 1014, paragraph 2 is an extract from the case of Osborne in the Supreme Court. And paragraph 3 is an extract of paragraph 53 in Osborne. And what that extract effectively provides is that an oral hearing will sometimes, if not often, be required. Paragraph 4 frames the dispute about costs. Paragraph 5 makes the point that the claimant says the two so-called issues which the Parole Board invited the court to decide were not in truth issues requiring decision. The first didn't arise on the facts, and the second had already been decided by the Supreme Court. That's paragraph 1 of, first sentence, paragraph 5. The two issues that the Parole Board sought determination at paragraph 7 is set out at the top of 1016. The first actually didn't arise. First sentence, paragraph 10, I say at once the Parole Board in fact conceded an oral argument the first issue did not arise. And the second was clear guidance already exists. Then goes on to apply the Davies test, and it's 47.1 of the Davies test. And at paragraph 27 is the point that there was an unreasonable failure to bring the proceedings to an end by signing the proffered consent order, which would have saved costs and time. It's 27.28. So when we're looking at the proportionality points, the first is that 47.4 of Davies gives the discretion. The next is, as the judge found in the case I've just taken you to, as was remarked by the Court of Appeal in Faulkner, it is incumbent on the legally aided party, or whoever the party is, to undertake a cost-benefit analysis. Now that applies whenever you've got small sums in litigation. If you are issuing a claim over £10,000, you will need to take a cost-benefit analysis. You will need to make offers. You will need to beat those offers so you can get an award of costs and indemnity basis, then not suffer the proportionality test under the new rules, in other words, post-2013 new rules. Now, what actually took place here is that the appellant did make a number of offers, but each one of those offers were inherently flawed. And part of the reason why they were flawed was not simply because of quantum. And these offers are I'm back in the supplemental bundle if I might take you there.
Do you mind, before we move around, as we're looking at summers for the first time, could we go to paragraph 22 and what Justice Foster said there at page 1020? The way that she read Davis as in the first sentence is that an unreasonable failure to concede a case may found an order for costs against the board. A risk of straying into later submissions. In this case, the consent order was not. It wasn't forthcoming, not simply because of the point you're raising, but because the board didn't accept the fundamental premise, as I understand it.
My lord, I will come to that, and I'm going to leave some of the mechanics to it.
We park paragraph 22, as it were, but
I know you want to come back to the reference.
Thinking, in what does a failure to sign a consent order consist? It's said here, it seems to me to be, in respect, sensible, that not concede a case.
It's got to be an unreasonable refusal to sign a consent order.
Yes, but when we say sign a consent order, I mean, actually, that could be also stated as concede a case.
Yes, as far as it's being unreasonable. But of course, the way that's framed as a consent order is that it presupposes that a consent order is going to be forthcoming from the party making the challenge, which then...
No, I don't think that it's common, it would be common ground that that's what this formulation, for example, means. That if the Parole Board has breached somebody's human rights and it won't concede it, why would that not fall within 47(1) of Davis?
The wording used in 47(1) is unreasonably declined or neglected to sign a consent order disposing of the proceedings. Now, in reality, I think the question comes down to whether there is a kind of positive or proactive obligation on the board to concede. And again, what I would say, and again, this is divorced from the context of this case, because all of the consent orders put forward in this case had a period for today that was far longer than that which was actually...
Well, I'm trying to, as you gather, I'm trying to pull out the focus that you're seeking to make, and just as to what exactly would have been on the consent order. But there was a much bigger issue here than what would have been on the consent order. It was that you didn't accept you'd done anything wrong.
Well, my lord, if I might come to some of the correspondence, because I don't think that's a fair way to describe it. What the board said in respect of these offers, and again, I'm going to leave it to my learned junior to go through the detail of them. What took place is these offers were made, said the period today was some 15 months, and the board said, I don't accept it. It wasn't that long, and some of the periods were obviously entirely unsustainable because part of the periods predated the tariff release date. So there was this kind of slight sense of otherworldly at it, but they've got to be understood in their proper context, which is the fact that much of the challenge period was pre-release and it became pure damages thereafter. And then the position the board took was, well, the consent orders are seeking a period which is unjustifiably long. We're happy to have written submissions on the costs of this to get the determination. We think we've been neutral, so we don't think we should pay costs, but we're happy to have written submissions so the court can adjudicate on that. And then please can we deal with the issue of damages in the county court, which, as you will have seen from the policy, is where you've got private law claims for damages, they invariably take place in the county court. And then they're just dealt with in kind of normal costs rules, so to speak. And that was the position that the board took. Now, I'm going to go to some of the offers, but I'll leave the exercise of putting flesh on the skeleton to my junior. But I don't accept the proposition, if it was being put in this sense, that the board simply put its hand up and says, I'm not engaging this at all. Actually, the board's position was, you want costs from us, but we think we've been neutral, so let's deal with that on paper. And when it comes to quantum, as per the decisions that my junior will take you to, this will be a private law claim in the county court. We'll deal with it in that form, rather than taking up a full day's high court time, so to speak. I'm not going to go further than that. What I do want to make on this particular point, and this is point number 2 on the proportionality argument, which is that if someone in the position of the appellant wants to ensure they get the costs they need and should make an operative order by operative, I mean one that they eventually beat at determination. What one sees.
Offer. I think you said order.
So I'm so sorry. Thank you, my lady. I'm at that stage where I'm conscious of time, so I'm already 3 words ahead of that which I'm actually delivering. But if one looks at the supplemental bundle and looks at the consent order, these consent orders were repackaged in the same form, but every single one of these consent orders, and again, these consent orders, if one gets a supplemental bundle at page 40, you get the covering letter of one of them. At the back of 41, it describes itself as a Part 36 offer. And I'm not inviting this court to encroach on the hypothetical question as how the regime in Part 36 dovetails with the practice in Davies. And that'll be an argument for a case whenever that matter arises. But if one then looks at the draft order at 42, which is exhibited to this email, and looks at paragraph 1 on page 43, each one of these consent orders that was put forward for my client to sign in paragraph 1 provides that the period for unlawful detention starts on the 31st of April 2022. That's paragraph 1 at the top of 43. Which is obviously unsound because the tariff date was the 14th of September 2022. So it's looking for this 15-month period to maximise the recovery. It includes at paragraph 7 cost provisions that the first defendant shall pay the claimant's reasonable costs. And again, given that the board was taking this neutral position in all of the documentation before the court to say we're trying to be helpful here, paragraph 7 is in and of itself predicated on the board acting in a way that it was not, in other words, actively participating in defending. And paragraph 1 has this period which is entirely unsustainable because it predates the tariff release date by 6 months. I'm going to come on to points 3, 4, and 5. Again, I'll take them relatively quickly. The first is that, again, when we're looking at this proportionality point, which is the ends and the aim, if the tribunal takes an adversarial position, costs will follow. And obviously, if it does take an adversarial position, then the appellant's costs will be that much greater. Because rather than this being 1 day against a body that's neutral, it would then become longer and more hard-fought. Point 4 is that there is no absolute rule requiring a costs order, nor is litigation meant to be free. This point, again, is made at Imperium Trustees at 1216 of the Authorities Bundle. And at 1216, which is tab 55, the board makes it clear at paragraph 80, and now I'll simply read this matter to you. There is no absolute rule requiring the availability of a costs order. Again, that's stating something that's self-evident. That's paragraph 80 of the Imperium Trustees at 1216. And equally, where the failure is that of the court, you cannot recover costs. That comes from the case of Steele Ford, which is at tab 20 of the Authorities Bundle. This is Steele Ford, House of Lords. And what took place in Steele Ford was that a judge of his own motion made an order against some solicitors. The solicitors then successfully appealed it to the Court of Appeal. The other party was the CPS that, because the order was made at the judge's own motion, the CPS didn't defend the order and didn't appear. And the question then was, in circumstances where the costs were incurred as the fault of the judge, could these solicitors who were the recipient of these costs orders then somehow recover their costs of having to go to the Court of Appeal to get this unlawful order set aside? And the House of Lords said no. So at page 192, from A to C on 192 is the background. That's A to C is the background, but a Crown Court judge makes an order for costs against solicitors. They then appeal it to the Court of Appeal. The Court of Appeal said the judge didn't have jurisdiction to do it. The solicitors then said to the Court of Appeal, please can I have costs against central funds? The Court of Appeal said, yes, you can. The Lord Chancellor then intervened, took it to the House of Lords that said, no, you can't. A to C is the context, and then the discussion is at the bottom of 201 from H. This is H at 201. I share with the Court of Appeal the view, which is no doubt held by every judge brought up in the English system, that it's just for a successful litigant, and perhaps a fortiori a successful appellant, to be able to recover his costs from someone. But unfortunately, that is not always so. Top of 202 is then the discussion about legal aid, which trespasses onto ground that we've already covered. And then it's just up to G on 202. And then I'm going to finish for the next 2 minutes just by making a series of miscellaneous points dealing with some of the other issues that have arisen. My lords, my ladies, so far as the question of listing being a judicial act, the second authority behind the ones that I've handed up is Adams and the Parole Board. Adams and the Parole Board was a case very similar to this. It was a non-decision case. You can see that from paragraph 3. Paragraph 3, almost exactly the same arguments as being set out here. And then at paragraph 20, we have exactly the same factual basis, which was there was an application for expedition that was refused. That's paragraph 20. And there was a challenge to the decision to refuse to expedite, along with a challenge to the delay in concluding the parole review. That's 20. Ground 1, which is above 27, is the alleged failure to act within a reasonable time. Paragraph 28, it is well established that listing is a judicial function. And this just succeeded. That's with reference to the case of Mackenzie and Leeds Crown Court, which is the authority behind this one. And it's paragraph 21 of this case. Paragraph 21 of Mackenzie and Leeds Crown Court. This was a challenge to a decision of the judge given COVID to not list a case, so to speak, and it's just paragraph 21, which is the proposition from this case that was put before the case of Adams and Parole Board. There is, of course, another and bigger point here, which is that there were 3 grounds of challenge that were put forward and heard by the judge, and 2 of them were to the decision not to expedite. The judgment at paragraph 15 and 16 expressly declares that the decision not to expedite was unlawful. And the grounds at tab 18 put forward 5 grounds. 2 permission was not granted in respective. 1 was the non-listing, and grounds 4 and 5 were the refusal to expedite. We can see that from page 192. That's grounds 4 and 5 on 192. It says, in relation to the first defendant decision, the 17th of October 2022, not to grant prioritisation or expedition to his oral hearing. So that's 2 of the 3 grounds were focused. That's 192, little Roman 4 and 5. Those are grounds 4 and 5. With permission being granted on 1, 4 and 5, and those were the ones that survived to the hearing. And as my learned friend Mr. Rule took you to yesterday, the application for expedition is at 209, and 212 is the refusal with reasons. The The reason is the timescales associated with the case were reviewed and appropriateness of prioritising or expedition the listing of the case was considered. However, the duty member concluded that the circumstances were not sufficiently exceptional to warrant this. That's 212 was the reason. So the factual premise for this point is unsustainable because actually 2 of the 3 grounds were about decision making, and in any event, listing is a judicial function. Those 2 authorities share. I've taken you to Faulkner, which provides that the fact that a convention breaches of Article 5 and 4 doesn't mean it gets treated any differently from any other. And so far as just satisfaction is concerned, I make one simple point about just satisfaction, which is even so far as the European law is concerned, it actually provides nothing more than the simple statement that costs may be awarded as part of just satisfaction. It actually sets out nothing that we don't already know, so to speak. But most importantly, just satisfaction as the basis for saying you need to give me costs because otherwise the charge will eat into my damages award was dealt with in Re CZ, and that's behind tab 38. Re CZ in 38, this very argument, you need to award me my costs because otherwise I won't get just satisfaction because the charge will eat into my damages, was rejected. And if I can take you just before I hand over to my junior, page 743. The local authority, paragraph 35, offered to pay costs for 2 very discrete periods. That's 35.1. And then at 37 is the issue, and the issue was, should I make costs to cover the whole period of the litigation? The costs themselves are set out at paragraph 46. The statutory charge is discussed at 47. 52, the claimants raised 3 main arguments in their claim to recover full award of costs. 1, that I should make the award under Section 8.1 of the 1998 Act because if I do not, the claimants do not obtain just satisfaction in relation to the award of damages. It's paragraph 52.1 on 749. And then at paragraph 58, there are 6 separate reasons for why that's rejected. But my Lord and Lady, I simply commend paragraph 58 to you, and unless I can assist you further, I'm going to leave it to my learned junior just for the next 20 minutes to deal with ground 7 and 8.
Thank you very much. Yes, Ms. Jackson.
Thank you very much, my lords and my lady. It falls to me to address ground 7 and 8, which I think can be characterised as the more fact-specific grounds that are raised. I'm going to start by setting out what we say is the correct approach to those fact-sensitive grounds, and then I'm going to address each ground in turn. I'm conscious of the time, so I will endeavour to cut my cloth. So firstly, then, in relation to the proper approach, you've heard a lot about the test in Davies and what, in particular, paragraph 47 shows, so I don't intend to go back to that unless that would be of assistance, but I just wanted to clarify that what we're looking at in ground 7, as the appellant puts his case, is the second aspect, as it were, of the first paragraph or first point in paragraph 47, which is whether the inferior court or tribunal, here the parole board, has unreasonably declined or neglected to sign a consent order disposing of the proceedings, and in addressing how that applies, I'll attempt to come back to my Lord Justice Peter Jackson's points about how the test in Summers might apply and the question of concession versus consenting. Then the ground 8 points raised by the appellant relate particularly to the second aspect of the approach set out in Davies, and essentially posit that neutrality has been abandoned. I'll address the question of whether neutrality has been abandoned in raising the points that arise under that ground. But I think it is just important to emphasise from the outset what the court have already seen, which is that we have in aspect 2 of Davies the point that neutrality may be abandoned and that could be a basis for a cost order, but we also do need to look at the third aspect of paragraph 47, which is the section that reiterates that neutrality will not necessarily be abandoned where, in this case, the parole board appears in the proceedings in order to assist the court neutrally on questions of jurisdiction, procedure, specialist law, case law, and such like. So again, I'm taking it as read that the tribunal is familiar with that test at this point, but I do think that is an important aspect of what neutrality looks like. So we're looking at the question of whether the board has abandoned neutrality and become an active party in this litigation. The other point I wanted to touch on in relation to the approach for this court to be adopting is in relation to the general guidance on how appellate courts should approach first instance discretionary decisions as to costs. So grounds 7 and 8 both essentially do amount to a challenge to Mr. Justice Fordham's exercise of his discretion. That's obviously the discretion exercise in accordance with the test in Davies, which you've heard about. But I just wanted to show you the authority of Straker and Turner Rose, which is at tab 26 of the authorities bundle, page 375. Now, I won't go through the facts in any detail because of the time, but in essence, this was a case that concerned a dispute over a conveyance. The defendant had made a Part 36 offer to the claimant in that case. That offer was a figure of £9,000, and that offer was put forward on a basis that the defendant believed to be the correct basis for the claim to be decided upon. The claimant did not accept that offer, proceeded with the litigation. The court ultimately accepted the basis that the defendant had put across, but made an award of a higher figure, something in the region of £11,700. So that was a case where the claimant had, in fact, beaten the Part 36 offer that had been on the table, but then was not awarded his costs because the court had considered that he'd failed to engage properly in the proceedings, and he subsequently appealed that cost order. Now those facts, as I said, don't have particular bearing, but the key aspect in terms of approach is set out at paragraph 2 of the decision at the bottom of 376. And what that paragraph says is essentially that an appellate court should be loath to interfere with the discretion exercised by a judge in any area, but so far as cost is concerned, that principle has real special significance, and that is for the reason that the trial judge has a feel for how things have operated. So that is quite simply the approach that I say this court ought to be applying when approaching these fact-sensitive grounds, and the decision reached by Mr. Justice Fordham. So with those principles in mind, I'll address first ground 7, which is, of course, the ground relating to the alleged unreasonable failure to accept a consent order when presented with an opportunity. I just wanted to pause because I understand from Mr. Rule's submissions yesterday that a slightly wider point is also being taken against the parole board, which is the parole board's failure to engage in settlement negotiations, full stop. If that is the appellant's case, I'll address that after I've come to the points about the consent order. As Mr. Cohen said, I will come back to some of the points of detail in Summers and have a look at how the principle in Davies has been applied. So if I could ask you to return up the case of Summers, which is at tab 49, we're at page 1012 of the authorities bundle. Now, Mr. Cohen's already summarised the facts, which I won't recite, but we of course have Mrs. Justice Foster's decision, And if I could take us straight to paragraphs 21 and 22, which are the paragraphs that my Lord Peter Jackson was asking about. What we have here is Mr. Justice Foster's application, as it were, of the Court of Appeal's decision in Gourlay. And I just wanted to emphasise here, so paragraph 21, we have the statement there that that if the parole board is not actively contesting a claim, that doesn't mean that, that if the parole board doesn't concede a claim, that doesn't mean necessarily that the parole board is actively contesting it. So we have a recognition that a failure to concede doesn't displace neutrality. And then at 22, we consider to see Mrs. Justice Foster essentially translating what Lord Justice Hickenbottom says in Gourlay to recognise generally that there is no rule on the parole board obliging a concession to be made. And what we've seen in the facts of Summers, as Mr. Cohen took you through, was a case where, notwithstanding the fact that the parole board is not obliged to concede a claim, in that case, and I'd like you to have a look at paragraph 27 for the encapsulation of the test here, which is at 1022. In that case, even though the test is not that there's required to be impropriety or wholly unreasonable behaviour, that's the first aspect of the Davies test, nevertheless, the parole board had in that case acted improperly with regards to the Davies test because it unreasonably failed to bring the proceedings to an end, and in a case that was, if we go to 30 and 31, described to be a case that was obvious and therefore consistent with the overriding objective, and I'm reading from 31 here, that effectively hopeless cases are settled. So that's the situation that we were looking at in Summers. We were looking at a case that the court considered to be obvious and hopeless. So just drawing together what I take from Summers, which, as I say, is obviously a High Court decision, but is one that's seeking to apply authority above. So there is no obligation to concede a claim for judicial review or enter into a consent order on the parole board. The key question is whether it was unreasonable for the parole board not to do so. And when we look at how that's applied, the threshold test for unreasonableness that's at least put forward by Mrs. Justice Foster is that the case must be hopeless or obvious in order to meet that bar. So that's how I explain Summers and how it applies to this case. Now to look at how we actually do apply it to this case. Now I'm going to endeavour to take this at a relatively high level given the time, but if it would assist to go to any more of the documents than I'm intending to, I can of course do so. But my broad points, firstly, is the one that Mr. Cohen has already put forward, and hopefully I don't need to go back to the documents here, but it is the point about the dates put forward in the consent order. The consent order did not put forward dates that were subsequently upheld by the High Court. The period of illegality is something that the parole board is entitled to remain neutral on, and in this case it is something that was borne out by events, and that Mr. Justice Fordham did note that the tariff expiry date was the 14th of September 2022. I'll give you the reference, that's at paragraph 5 of his judgment. At paragraph 3.2 of his judgment, we see the principle set out that the tariff expiry date is the touchstone for assessing delay. And ultimately, at paragraph 15.4 of the judgment, we see that Mr. Justice Fordham rejected the period of 14 months that was put forward and instead made an order for 10 months. So that is, in my submission, clearly a set of circumstances where it cannot be said that the parole board had an obvious or hopeless set of circumstances. It was one in which the court actually ultimately did not find in accordance with the case that the appellant put forward. The second point to touch upon, though, again, I think the board quite squarely has the point that each of the offers put forward, where they put a figure, were for a figure of 15,000, which was over the amount that was recovered. My lady Elisabeth Laing has noted that the relationship between the period and the cost here, I don't think I need to take that any further. But for completion, I just wanted to emphasise as well that while these were two quite significant issues that the offers put forward to settle, there were some additional issues that were raised in the consent orders that were put forward to the parole board, that were pointed out by the parole board, and yet the appellant continued to put forward further proposals of settlement that did nothing to address those issues. So again, I will try and take this quite rapidly, but for example, if we go to page 25 of the supplementary bundle, we have a consent order there proposed on the 30th of October, so I think it was the first one. There are recitals relating to the systemic challenge, which was not subsequently granted permission. If we look at the first order, we've seen this order, it has a period, but it also has a declaration. The parole board hearing was unlawfully delayed. That declaration is reflected at paragraph 1 there. And we see at paragraph 5 a costs order, which obviously for reasons that we're all very familiar with was unacceptable to the parole board. And then if we turn over to 27, we see a letter back shortly afterwards on the 14th of November from the parole board, essentially articulating a number of issues with that order, which meant that even though, as it said at the end, should you amend the proposed consent order accordingly, our client's prepared to consider an amended draft consent order, this particular offer wasn't one that the parole board was able to accept. And then I'm going to short circuit this by jumping straight to page 73 of the same bundle, if I may.
Before you leave,
Of course.
top of paragraph 28 is the passage that Mr. Rule was emphasising at the end of the first paragraph.
Yes, indeed, and I would like to come back to that on ground 8, if I may. But that is a point that is raised throughout the correspondence, and I'd like to contextualise that, if I may, when I come back to ground 8. But you're quite right, my lord. But yes, if we jump to 71. We have, sorry, I've taken you slightly later, but we can start here. This is the order that was put forward on the 14th of June 2024, so quite a lot later in the proceedings. And then if we move forward to the response to that, which is at page 73 of the bundle, we have a letter from the parole board essentially setting out, if we go on to page 74, 73 and 4, that, so in respect of ground 1 at the bottom of 73, the same point made about the declaration. Go over the page, we've got the public law issue, which we'll come back to, and then we've got, again, the point in relation to costs that's still a feature of this order. So the simple point is that there were a number of issues that were raised by the parole board in terms of the order that was being put forward for settlement that meant, in the parole board's view, it was unable to accept it. And none of those issues have been addressed in any of the subsequent orders that have been put forward. So stepping back, the simple submission is that in this case, it's hard to see how the parole board can be faulted for failing to compromise a claim on terms that the appellant in fact failed to beat, and in a way that was, in the parole board's understanding, and in a way that was not seemingly addressed or grappled with by the appellant, not acceptable in any event as matters of procedural law.
Reading paragraph, page 74, second page of the letter that you've taken us to, and the list of points that's numbered there. I mean, it's quite punchy.
It is quite punchy, and I will again address that when I come to neutrality, if I may, because that's again a point that comes up and is made against me in relation to what is suggested.
I mean, when I say punchy, it's threatening cost consequences to the other side.
It is at this stage, but that is a point that's taken against me in ground 8, and if I may, I would like to build up.
Just
that.
As we're not going to be going back to these letters repeatedly.
I appreciate that. Well, I'm going to leave it now, and I'm going to address then the points in relation to neutrality, and I will do so in under 4 minutes. So, in short, we've seen what Davies has to say about neutrality. unsurprisingly, my headline submission is that it was clear in all documents and in all oral submissions that it wasn't abandoned. The specific point against me is that set out at paragraph 57 of the appellant skeleton, which is in relation to the threatening of a costs order if he, the appellant, didn't actively transfer to the county court. And he relies on 5 pieces of correspondence. Now, there are a couple of just very short points that I wanted to make. And I'm going to do this by starting with page 102 of the bundle, which is the appellant submissions in the High Court. And it's paragraph 6 and 7 at the bottom of 102, relating to venue for the claim. And what you have there is the appellant observing, and in my submission, this is the point. The point is that there is no threat. There is no. There is little more than an invitation. It's not even really put forward as a submission. It's an invitation or a suggestion to the court that the county court might be the appropriate venue for this hearing at the point at which the appellant, since the point that the appellant was released. Now, 2 authorities are relied on there. You do have a copy of them, and for your note, I just wanted to show you the dicta of Mr. Justice Dingman's at the end of ZA Pakistan from paragraph 68 onwards. But I just wanted to make very clear that we don't need to debate out the venue point. We don't need to decide who's right or wrong in the event Mr. Justice Fordham decided to retain the decision to himself. But this only goes to the context as to whether this is a point that indicates an abandonment of neutrality by the parole board. And my submission is that if we have a look at what Mr. Justice Dingman says from paragraph 78 onwards, and again, due to the time I will take this at a very high level, but he essentially says that matters such as, in particular, in detention-related matters, where the public law issue, i.e. the ongoing detention, is no longer an issue, it will generally be appropriate to transfer that matter to the county court for a whole range of reasons that are reflective of the overriding objective, the good use of court time, and also in relation to the county court's ability to successfully decide such matters on the basis of evidence and so forth before it. So my simple point is that the position of the parole board in suggesting transfer to the county court is one that was made in light of guidance from the Court of Appeal that suggested that this was an appropriate course of action. So it's not some sort of outlandish and controversial point that was being taken and pressed by the parole board. It was simply reflecting the guidance that has been received, and Roche, which you've also got, is a decision where broadly a similar approach was taken. But the key point for my purposes is...
Sorry to interrupt, Ms. Jackson. Sorry. Could you just tell me the tab numbers, please, for ZA Pakistan and Roach?
They've been handed up, I'm afraid. Yes, I think Mr. Rule helpfully handed up Roche yesterday.
Sorry, it's my fault. Several skips behind the beat again. No, that's fine.
Thank you very much. So I just did want to canter through the context, because I think it is key to address the points that my Lord Peter Jackson has raised. It's hard to do this rapidly given the fact that it's all quite case specific. But the first, there are 5 items of correspondence that are relied upon by the appellant. Now, the first, I won't need to take you there because it is that correspondence in relation to the consent order that we've already had a look at. My Lord noted that that is a letter in which transfer to the High Court was, to the County Court rather, was suggested. The second piece relied upon is the 14th of December 2023 letter. Now, instead of showing you all the context that led up to that letter, I'm going to jump straight to that at page 36 of the bundle, if I may, the supplementary bundle. So we have here a recital of the context that has led to this point. So we have an email of the 15th of November where it was indicated that the claimant has been released and it was invited that potentially transfer would be appropriate. There was emailing then on the 15th of November on a number of occasions Indeed, there's a whole chain of emails that if you have a look at 33 and 34 of the bundle, you'll see repeated attempts to contact the appellants that were met with tumbleweed. And then it's in that context that the parole board puts forward that we intend to write to the court suggesting this is an appropriate case management approach, it being transfer. Again, without any insisting or threatening, a simple letter sent out to indicate what the parole board at that time thought was the sensible course of action in light of the events that had taken place. The next letter then comes at the 20th of December. That's paragraph 38. This is also relied upon by the appellant. Again, I don't have time to go through it in detail, but the headline point is that the parole board expressly maintains its neutral stance. It notes its duty of candour to inform the court that the appellant has been released. No one had done that at that point. Recites the history that's led to this point. And then, again, sets out the parole board's understanding of what the appropriate next step would be in terms of venue. Again, properly characterised, this is a reasonable case management invitation well within the confines of what's anticipated by Davies. And then finally, we get to that letter of the 21st of June, which is the letter that we were just looking at, and we are looking at those 5 points. But I do just want to take a second to make sure that this as well is contextualised. So firstly, this is a letter that followed at this stage, no, apologies. Yeah, so this is a letter that if we follow through, we have the suggestion again about the transfer to the county court, which appears...
Where is this letter? Remind me where the letter is.
I'm so sorry, page 73 of the supplementary bundle.
Thank you.
So at the top of page 74, we again have the suggestion of transfer to the county court. We then have the paragraph third down that says, in relation to costs, our client made no submission. We have the repetition of neutrality. Then we come to an introduction to these 5 points that says, if you wish to continue this claim, our client will comply with reasonable disclosure requests, but reserves the right to remind the court that. And the reasonable disclosure request here is key. Now, I don't have time to show the court all of the background to this, but again, at a high level and giving references, if you wish to follow them up, the reference here refers to the fact that initially, of course, the appellant sought judicial review on a number of grounds. Mr. Justice Eyre refused permission on the systemic grounds that were advanced. The appellant sought to renew those grounds. He sought then subsequently a detail in relation to statistics and so forth in relation to the queue, which was put forward on the 2nd of February. The parole board provided that list of statistics on the 21st of February. The appellant subsequently agreed to withdraw his renewal of the grounds on the 14th of June 2024. And then we get to this letter, which is in the face of a suggestion from the appellant, which is at page 69 of the bundle. We don't have time to go there, of course, but that says that the statistics mask the level of unlawful delay to some cohorts and are notably less informative than the original statistics, which subdivide matters, and that he reserves the right to make Part 18 disclosure requests concerning the statistics. And it is in that backdrop and in the face of quite extensive correspondence in which the appellant sought to obtain disclosure, allegedly pursuant to the duty of candour, on grounds that weren't even an issue and that he had since decided to withdraw, that we now get to these quite punchy comments. And even then, if we read the punchy comments, and in particular in relation to transfer to the county court, the simple point that the parole board observes is that there may be cost consequences flowing from the fact that there has been no public law issue since the 7th of November, over 7 months ago. So in my submission, it's quite a stretch to say that in light of all of this context, this is a threat of a cost order. It's not a threat of a cost order. It's a reflection of the fact that there may be cost consequences for actions. And it's also, in my submission, a stretch to say that this is active participation in a claim in light of that context. So I'm conscious of the time. I will leave it there unless I can assist further.
Sorry to ask another question, Ms. Jackson. At the end of page 73, GLD say there's been no conclusive finding or concession that the delay was unlawful. So, what does the letter mean when it says there's no outstanding public law issue? Is the lawfulness of the delay not a public law issue?
I think perhaps there is some nuance in wording that could be drawn out here. I think I don't have instructions to say it's inaccurate. I think the point being made in respect of the point being made in respect of Grant 1, I think is the.
It seems to be on the face of it that if you're not conceding that the delay was unlawful, that does raise a public law issue.
I think there is. I think perhaps the framing of there being no public law issue is one that's unfortunate. I think the point is that if the public law issue is the ongoing detention of this individual, the fact that he's now been released means that that underlying issue.
Distinction between historic detention and continuing detention. But so the suggestion is that the county court will be deciding not only the amount of damages for an agreed period of detention, which one can understand is something the county court regularly does. The county court will be required to decide whether the detention was unlawful at all and its period. Is that right?
That is quite right. And if my lady wishes authority to confirm that that is understood to be something that the county court can do, can I invite you to have a look at paragraph 22 of the Roche decision?
Sorry, just let me get. Thank you.
Where is Roche?
Roche is the other decision that was handed up. It was actually handed up by Mr. Rule yesterday. I have further copies if it would assist.
Can't find it.
That's why I can't find it.
I don't think.
Here we go.
Yes,
I've
thank
got them. The copy I'm handing up now is actually sidelined, if that is of assistance, but I didn't see the need to hand up the further copies. Paragraph 22. Again, I've tried to take it rather rapidly, but I think the simple point is that Mr. Justice Dingaman's dicta in ZA, and then read together with paragraph 22, essentially recognises that the county court can be well placed to essentially determine those matters which are relevant to the damages claim. One doesn't necessarily need a declaration of the High Court in order to have the damages that follow from the county court. So,
You mean 20?
22.
22.
No, 22 just says it suggested there hasn't been a full admission.
Oh, I'm so sorry.
That may have been strict position. Now,
Sorry,
today-
24. It's 22 read with 24. Thank you. The two read together essentially do make that point.
But that was a case where, by that stage, it had been accepted that the
Yes.
detention was unlawful.
Paragraph 19.
It was, and again, I've taken this much faster than I'd like to. That was a case in which actually the parole board had essentially admitted liability. I think the point at 24 is reflecting that nevertheless it is possible to have that period decided.
It was exactly the same sort of claim.
It was not quite the same sort of claim, but in the circumstances that Mr. Justice Dingaman's envisages, I think it does equate. There is commentary at 71 that in that case the appellant claimed a declaration that past detention was unlawful and that the respondent's policies hadn't been changed. However, in reality, the claim for declaration added nothing to the claim for damages. I can see I'm taking this slightly too fast, and I can see that the court's concern is that perhaps it was required that the High Court did make a decision as to the period in order for the county court proceedings to follow. I would fall back on the point that I hopefully made clear at the start. I'm not trying to have the debate before this court as to what the appropriate venue for these proceedings were. I'm simply trying to make the case that the parole board, at the time that this correspondence was taking place, took the view that transfer to the county court may be an appropriate course of action, put that position to the appellant on a number of occasions, didn't really hear back. There was a letter from the 9th of January, which the parole board wasn't actually copied into. And in the event, put that suggestion to the court, the administrative court, and Mr. Justice Forden didn't take that course of action. So the issue here isn't whether the appropriate venue was for the county court. The issue is whether the parole board abandoned neutrality in suggesting that potentially the county court was the appropriate venue. And in my submission, whether it was right or wrong about that fact, it was contextualised within what the parole board understood to be decisions that guided its suggestion. And either way, putting that suggestion forward was not one that meant it was actively contesting this issue. And that threatened cost order, I hope I've contextualised in the situation that had come before that. Again, I'm very conscious of the time, and I hope I haven't created additional confusion by trying to take matters faster than they could have been. But unless I can assist further, those are my submissions.
No, thank you very much, Ms. Jackson. Now then, Mr. Bedford, how long do you want? How long are you expecting to be?
Well, I would have thought no more than half an hour, if that's possible.
It's actually convenient.
No, it doesn't matter. No, it's fine.
Can we rise and come back at 2?
Yeah, well, let's do that. We'll rise now and see you at 2 o'clock.
Thank you.
All rise.